Welcome to day 2 of our conference. I think you would agree we had a fabulous start yesterday with day 1 of our national conference. I did mention yesterday that Cairns was the birthplace, if you like, of our first conference. Is there any people here that were at that 2008? I know Michael Midwell and you were. Were there? You've got a few? Great. Oh, welcome back. Any that are at their first conference this year? Wow, okay, fantastic. Oh, welcome. Well, may there be many more to come for you, and welcome. So we've got a bumper day ahead, mainly with a family law focus, and then we're concluding the day with our wonderful conference dinner at Jacopi Cultural Park, so we're going to have a fantastic day 2 ahead. But before we introduce our first speakers, I would like to again acknowledge our conference partners and sponsors, because without them we really would struggle and we'd have a lot of challenge putting on a conference of this quality. So our conference partners this year again, Department of Social Services and the Attorney-General's Department, who support us every year and have done since our first conference. Our gold sponsors, Better Place Australia, Uniting Care and Drummond Street Services, and our silver sponsor, Interrelate, and mobile office sponsor, Anglicare Australia. So many thanks again to our sponsors. As I mentioned, this morning's session will have a family law focus. As we look at the range of recommendations currently being debated as part of the ALRC's review of the family law system discussion paper, what is clearly identified is that the family law system does not operate in isolation from a broad range of other service systems and programs. Children and families engaging with the family law system often come into the system with a connection to child protection, family violence, drug and alcohol and mental health services, financial counselling services, police and justice systems. Or if they are not, they may well have a need for accessing these and other services. Reviews and change can create a sense of uncertainty. However, it would seem that the Commonwealth Government is taking a staged approach in any reform of the family law system. There is, of course, the reform of the court system that is being debated on the legislative platform. And of course the ALRC's review of the family law system just noted. As such, it was certainly welcome news earlier this month to hear that the Commonwealth Government would be extending the original time frame of continuing to fund family law services from 3 to 5 years. This will give more certainty for services and the ability to plan. The original commitment was announced at the National Conference last year for those that were here. Then earlier this week, the Minister for Women announced that FRSAs would receive additional funding of $50 million over 3 years to fund FDR in property matters. This will be voluntary, but it certainly opens up another avenue for our members to build on their strengths as expert mediators and dispute resolution practitioners in the field of family law. Today, we're delighted to introduce Queensland Senator Amanda Stoker, who has been asked by the Attorney-General, the Honourable Christian Porter, to attend our conference and speak on his behalf. An interesting political fact is that Senator Stoker replaced the retiring former Attorney-General George Brandis as the Liberal Senator of the Australian Senate representing Queensland. She came into this role on the 21st of March this year. She is herself a barrister and has served as a Commonwealth prosecutor, as well as a Judge's Associate to Philip McMurdo in the Supreme Court of Queensland and to Ian Callanan in the High Court of Australia. Immediately prior to her appointment in the Senate, Amanda was a member of Level 727 Chambers, a sessional academic at Central Queensland University, and Vice President of the Women Lawyers Association of Queensland. So could you please join me in giving a very warm welcome to Senator Amanda Stoker.
Thank you. Good morning, one and all. Thank you for that warm introduction, Michael. I very much appreciate it. May I begin with a few acknowledgements. Mr Michael Austin, the Chair of the Family and Relationship Services Australia Board, His Honour Matthew Myers, Judge of the Federal Circuit Court of Australia, and of course His Honour Joe Harmon, Judge of the Federal Circuit Court of Australia, as well as the traditional owners of this area, the Yidinji people. I'm really delighted to be here this morning to represent the Attorney-General of Australia, the Honourable Christian Porter, to deliver this address. The Attorney-General extends to you all his apologies for not being able to join you for your conference this year. I know he very much wanted to be here. But can I begin by thanking you for your ongoing work in this important field, responding to the needs of Australia's families and providing them with the services and supports they need at a critical time in the family life cycle, and often a really challenging time for all of the people involved. This address is an opportunity to provide something of an update of what the Australian Government is doing and is looking to into the future that touches upon your important profession. Since the commencement of the Family Law Act more than 40 years ago, Australian society has undergone quite profound cultural, social and demographic changes. Yet one thing is as true now as it was at the time of Federation, and that is that the health of families is the fundamental building block of our nation. The government is focused on shaping a family law system that supports the needs of Australians today and well into the future. We want to ensure that Australian families can resolve their disputes quickly and easily when they arise, and with as little expense as is possible, so that they're able to move forward with their lives in a constructive way. That's why the government directed the Australian Law Reform Commission to undertake the first comprehensive review of Australia's family law system since the Act commenced. That review, and I expect you'll probably hear something more about it today from the Commissioner, is due to report to government in March of 2019. The terms of reference are broad and far-reaching. They require the Australian Law Reform Commission to consider the appropriate role of the family law system in modern-day Australia. The ALRC has been asked to consider proposals for change that would support families who need to engage with the family law system to resolve matters quickly and safely and with the minimal financial expense. The overarching priority must always be the first interests and the best interests of children. In addition, the review is also considering possible reforms to the legal framework for family law, how family law support services are designed and delivered, and the way that professionals working within the family law system are regulated. The ALRC is looking for ways to facilitate better collaboration, coordination and integration between the family law system and the state and territories' family violence and child protection systems. And anybody who's been looking at the Queensland press this week will be feeling with a heavy heart the urgency of making that improvement. On the 2nd of October, the ALRC published a discussion paper which set out 124 proposals for reform to the family law system and asked 33 questions on which it is seeking feedback from stakeholders. The purpose of the discussion paper is to generate further input, and the government is really interested in maximising stakeholder contributions on these proposals, and so it looks forward to receiving the final report from the ALRC come March next year and to engage with and act upon the recommendations that are made. I understand that the ALRC has consulted with many of the organisations that are represented here today. To each of you who have been involved so far, thank you for your positive engagement with that review process and for generously sharing your time and your knowledge and the depth of your expertise with the review team. I know it helps particularly new politicians like me immensely to have the expertise of people who have decades in the field. We are at a critical point in time for the family law system. There's a sense of frustration among parts of the Australian community, and Australians make it very clear that they want fast access to fair and just outcomes through the family courts. They are, in a sense, difficult customers, often people coming to the system with problems of their own and conflict that runs deeper than the court process was in its many years ago's design adapted to deal with. The government has committed to act now to address critical points of tension in that system. That's why urgent reforms are currently being implemented to change the structure of the federal family court system. The ALRC is not considering the structure of the federal courts, however. Any ALRC recommendations, though, that go to court processes that merit implementation will be more easily and effectively implemented in the new and simplified structure. On the 23rd of August this year, the government introduced legislation into Parliament that would create a Federal Circuit Court and Family Court of Australia by bringing the Federal Circuit Court and the Family Court together under a common administration and governance structure. These reforms would establish a single point of entry for family law matters, provide a more unified approach for federal family law more generally, and allowing for more effective early triage of cases. It would mean that, in essence, there would be no wrong door for people who want to access the family court system. Importantly, the structural changes will support the Federal Circuit Court and the Family Court to adopt a common approach to case management and to the triage of cases. Better case management within the court system will mean that risks are more consistently identified and that families with complex needs are referred to and, more importantly, receive the support and assistance that they require in a timely manner. The Federal Circuit and Family Court of Australia reform package will enable positive changes for families that are navigating the court system, particularly for the first time, during what can be an incredibly stressful and difficult time for them as individuals. In addition to progressing these structural reforms, the government has also provided assurances that more than $815 million in funding will be provided over the next 5 years to ensure that key services to the sector continue. These include essential family law advice, dispute resolution, counselling and social support services, children's contact services, and educational programs for families. This demonstrates the government's ongoing commitment to assisting and supporting Australian families during times of immense emotional and financial stress. The government has also announced over $114.8 million in additional funding for family law services and initiatives to support women's economic security after separation. Earlier this week, you may have noticed that the Minister for Women, the Honourable Kelly O'Dwyer MP, delivered the inaugural Women's Economic Security Statement and announced a package of measures to support women's economic security. New funding will be provided to new programs to support women's workforce participation, earning potential, and economic independence, all of which are connected to women's outcomes as they emerge from the family law system. You don't need me to tell you that a relationship breakdown is a difficult and often traumatic time. It's also expensive and tends to put women back, on average, at least 6 years in financial terms. The Morrison government will provide $50.4 million to provide mediation services to help Australian families reach agreements about dividing their property after a relationship breakdown. This new funding will be provided to family relationship centres and legal aid commissions across Australia to more than 30,000 families each year. This investment for property mediation services supports the government's policy to assist families to resolve their family law disputes outside of the courts wherever possible. Funding will also be provided to the family courts to develop a simplified process for determining what could be regarded as small claims property disputes, where the total value of the property pool is up to $500,000, excluding debt. This specialised case management process will make the property division process simpler and quicker for separated families who possess smaller joint property. No conversation on this topic would be complete without also discussing family violence. The government will also provide $7 million over 3 years for legal aid commissions to provide legal representation to parties subject to the ban on direct cross-examination under the Family Law Amendment, Family Violence and Cross-Examination of Parties Bill of this year. If passed, the bill will ban direct cross-examination where there is an allegation, charge or conviction of family violence, a final family violence order, or a family law injunction for personal protection. The court will also be able to prohibit direct cross-examination at its discretion. When the ban applies, cross-examination must be conducted by a legal representative. The government has worked really closely with your profession to develop this approach in an attempt to balance the need to protect victims of family violence, and particularly attempts to intimidate them throughout the court process, and balancing that against the need for procedural fairness for all parties. The ban will remove the fear of being directly cross-examined by a perpetrator of family violence as a factor in a woman's decision on whether or not to settle a matter, and to encourage women who have experienced family violence to pursue their legal entitlements. Feedback from your profession had been telling us that many women weren't exercising their rights under the family law system because they were intimidated by the prospect of facing a perpetrator of violence in court. Finally, the government has committed ongoing funding of $31.8 million over 3 years from the 1st of July 2019 to continue and expand its investment in specialist domestic violence units and health justice partnerships. These services deliver integrated legal and social support services to women experiencing family violence at 21 locations of high need across Australia. The existing services provided by community legal centres and legal aid commissions will be expanded to offer integrated financial support services to women, such as advice, counselling and financial literacy. These financial services will support women to avoid circumstances of financial hardship that we know all too frequently follow separation from a violent partner. Finally, I'll turn to another important issue for the Morrison government. With our population ageing, the unfortunate occurrence of abuse of older Australians is either on the rise or is coming to our attention in ways that it hadn't in the past. Abuse of older Australians is a complex health and social problem with far-reaching impacts for individuals, their families, communities and society as a whole. It can fracture family relationships and result in older Australians requiring a lot more assistance from the health system, more financial support from the government, and more assistance from various service and community sectors. While further research is being undertaken, we currently estimate the prevalence of elder abuse in Australia to be at around 5%. That is, around 185,000 people aged 65 years and over are currently experiencing abuse in Australia. The Morrison government is investing in a range of approaches to tackle the abuse of older Australians. These include the development of a national plan to respond to the abuse of older Australians, and a knowledge hub to provide centralised information for older people, carers and professionals, and $18 million for service trials which will be rolled out in 2019. I'm really pleased that the government is focusing on the needs of older Australians through this work, particularly by combating and preventing abuse by family members. While it is expected to be more focused on potential institutional failings, the newly announced Royal Commission into Aged Care will, I expect, shape our response to elder abuse into the future. While it is certainly an ambitious agenda, I'm confident that this work will contribute to raising the public profile of the abuse of older Australians, and with that awareness, generate a greater action and a greater community sense of responsibility for dealing with this problem in our midst. I conclude by congratulating FSRA on the 10th anniversary of its national conference. The theme of your conference this year, Be the Change, Leaving No One Behind, is timely, and it will no doubt generate plenty of constructive conversation about systems and services that are adaptable and responsive to the evolving needs of Australian families. The government is really proud to support this worthwhile event and your profession. I wish you well for the remainder of the conference and encourage you to contribute to the discussions that follow, as they will help to shape the future of Australia's family law system. Thank you for having me at your conference this morning.
Senator Stoker, thank you very much for your address, and I think it's fair to say, isn't it, the significance of the reforms and investments that are underway are major, and I think it's fortuitous that we've really set aside so much time today to focus on these, and thank you for setting us off so well, and the commitment of the government for such a significant review that I think has very much been sought after for some time. So could we please thank Senator Amanda Stoker again? Thank you.